Tax Rep Network is brought to you by Bench, America's largest bookkeeping service for small businesses. Bench is committed to supporting business owners that have fallen seriously behind on their books, something that is all too common in representation work. They combine powerful technology and an in-house expert bookkeeping team to deliver accurate financials for every year of missing returns. Bench specializes in tough cases, solving even the most complex, difficult, and time-consuming client challenges. Working with Bench means more time for you to focus on actively working rep cases, problem solving, and growing your practice. What's more, they're fast, meaning you'll be keeping clients and revenue officers happy. It's a win-win. One of the greatest things I found is that if it's a really big, messy case, they can throw more and more people at it versus anyone I could find locally. Once Bench helps your clients fully catch up, their monthly bookkeeping service keeps them out of trouble, ensuring you can provide a truly lasting resolution. Bench's partner program is perfect for tax pros that need a dependable resource they can trust to get their clients caught up. With meaningful partner benefits and dedicated support, Bench already works with many tax rep members. Find out more at www.bench.co/taxrep. That's www.bench.co/taxrep. So how do I call the IRS and get through much faster? How do I avoid those courtesy hangups that the IRS does? I use Call ENQ. ENQ is a service that you can use to get through to the IRS much faster, get to a representative, and basically get your case resolved. We set up a special arrangement for Tax Rep Network listeners where you can try the service, get 200 minutes for $19.95. For less than $20, you get 200 minutes and you will save hours and hours and hours of time and frustration. Just go to callenq.com/TRN. Again, callenq.com/TRN as in Tax Rep Network. Try the service. It will literally change your practice. How do I manage my tax rep practice? How do I get transcripts? How do I track what is going on with the IRS with every single one of my client cases? How do we complete the offer forms, the powers of attorney, everything? We use Tax Help software. Tax Help software is the cornerstone of our practice. We use it for its intelligent ordering. Every single night, it will update the transcripts on our clients, so we will see things happen long before those letters even go to the mail. We can then, react. We can let the client know. We can get all the transcripts we need to determine what our client's best options are, when is the debt going to expire, and we can fill in all of the IRS forms and get them filed accurately, the analysis done correctly. If you're interested in giving it a test, go to taxhelpsoftware.com, use promo code TAXREPTRIAL, all one word, all caps. You will get a free 2-week trial. Again, that's taxhelpsoftware.com, TAXREPTRIAL, all caps for a free 2-week trial. If you love it and want to buy it, use TAXREP10, capital, all caps, TAXREP10, TAXREP10, all caps, one word. You'll save 10% on your purchase. It will be the engine that runs your tax rep practice, just like it's what we use for ours. All right, everyone. Well, thank you for listening in on the Tax Rep podcast. As I promised, I brought Gwen Moore back. And on top of that, we've dragged Ajay Gupta in with us. Ajay is of counsel to Gwen's firm. He's in Atlanta. And I'll run through a very quick, long bio on Ajay. But what we thought we were going to do today is talk about the life cycle of a criminal tax case. Which there's a lot of misunderstanding about, I think, because too many people watch late night TV and believe that that's actually what happens in a criminal tax case. But if you're just listening in for the first time, so joining me, I'm Eric Green from Green and Sklar's Tax Rep Network. Joining me is not only a colleague and a friend, but someone who actually co-hosts the podcast from time to time. Gwen Moore. Gwen is in Chicago.
with her own firm, although she seems to be spreading everywhere now with people in Atlanta and New York. Maybe she'll buy us. She'll be in Connecticut. But Gwen obviously does civil and criminal tax controversy, and has a column for Forbes, which if you're not following, you really should. As I mentioned, AJ is of counsel with Gwen's firm. He has done everything from tax planning in Silicon Valley to being an assistant United States attorney prosecuting tax cases. He's involved at the Chicago Divinity School, teaches as well. Basically has got a wealth of experience and knowledge in this area. And if both of you, listen, thanks for joining me on the podcast. It's great to have you.
It's great to be here.
Thank you for having us, Eric. Always fun to talk tax with you.
If you have to talk tax, yes, we can make it fun. So I get a call from a client of mine who's basically become a friend. And he says, look, he said, I got to talk to you. He said, these two criminal guys from the IRS just left. And I was like, excuse me? He said, yeah. Two dudes from the IRS came down to talk to me. They just left. I'm like, whoa, wait a minute, time out. Why were special agents there? What did they want to talk about? They want to talk about this or that. Did you tell them anything? No, of course not. Well, how long were they there? 2 hours, which is not a good sign, by the way. And what I wanted to open up with is we can talk a little bit about the tax crimes and sort of how this goes. But one of the things I wanted to let everyone listening, if you've never been involved in a criminal tax case, congratulations. But for those of you who are interested in getting involved in criminal tax cases or have been, one of the things that you need to understand and what taxpayers need to understand is the IRS, when IRS special agents now have a case, they're not looking to collect money. They're not looking to just sort of clarify something. When they come out and knock on a door, it is because they believe they have enough evidence that a crime was committed that now they're going to see if they can get more information. They are there to try to get a conviction. So when my client tells me, yeah, they were here for 2 hours and we were talking, to me, that is a horrible, that's not what I want to hear. And so, AJ, maybe we should start with you. As an assistant U.S. attorney, criminal cases can be either administrative, right? In other words, the IRS agents have it, they're going to basically work the case. Or you have the parallel where they're going to bring in the assistant United States attorney early on. Maybe they want to use the grand jury process, subpoena, whatever. Can you kind of talk about both of those and from your perspective as an assistant U.S. attorney, when do these cases kind of, come across your desk?
Yeah, so the cases that are worked administratively tend to be mostly tax cases. So those are the ones that the IRS special agents investigate, and they bring them to the U.S. Attorney's Office for prosecution. The ones that are presented to the grand jury and are investigated by the grand jury, usually tax is one of the counts, but they tend to be, cases that have other counts involved, other financial counts, sometimes not even non-financial counts like drug cases, or could be organized crime cases. So that was my sense. That the pure tax cases tended to be worked administratively, whereas the cases that were investigated by grand juries, tax was one of the counts. Usually there were, money laundering, mail fraud, bribery, public corruption type cases, and tax was one of the additional counts in them. That tended to be.
It's amazing how tax touches everything, isn't it?
Yeah, and it is kind of curious, tax the tax count would be included in these larger cases, but because you need permission from DOJ tax to add the tax count at the end, even though when the cases were being worked, we always had the tax count, oftentimes the tax count would be dropped at the end, mostly because the tax count doesn't really add much to the guideline sentence. And so if prosecutors thought, their cases were pretty strong on the other counts, they weren't really that keen on including the tax count. Whereas, of course, if the case is being worked administratively and the CI agents have been working it, the tax is probably the only count in that. Of course, it was tax or nothing. So that tended to be the difference between how the cases were being investigated.
And, when it comes to tax crimes, one thing I've noticed, and I'd love, Gwen, to get your take on this. One of the things that we've seen a lot of, and I would almost say, in my mind, it started back when structuring became kind of a hot item a number of years ago. And for those of you listening who don't know what I'm talking about, structuring it's the crime where, let me think about this. Normally, if you deposit more than $10,000 in cash or cash equivalents, the financial institution reports that. Form 8300 is the IRS form. There's I forget what it is, the FinCEN form, 104, I think. Basically, they receive more than 10,000 in cash or cash equivalents. So the crime of structuring is where you break up your deposits to avoid the filing of that currency transaction report, or referred to as a CTR. There was a number of years ago where that was what the government was doing. They were going after everyone on structuring. They've sort of backed off that, but since then now we have John Doe summonses on check cashers. We have John Doe summonses on Coinbase, Kraken, and Circle. We have all of the information coming in from FATCA. So what we're seeing, because my practice, we do a lot of collection work, offers and compromise, working out installment agreements. A large part of my practice is civil administrative, dealing with the collection division. More and more, those cases are being worked up by the fraud, the enforcement office and sent over to CI because of evasion. And so, Gwen, can you expand on what evasion is and that there really are two types?
Yeah, absolutely. So really quickly, before I get there, I want to just go back to how you opened the podcast and talking specifically about your client who gave the agents who came to talk to him a 2-hour preview of what his testimony would look like, right? Because certainly as criminal defense lawyers, we shudder to hear that and think about what was said during that. And if I can share my screen for those of you who are on the YouTube, will be able to see if I can share my screen. Those of you,
I have to allow you to do that.
Okay, well, I can just describe it. I'll just say in our firm, and often it's too late, right? Because somebody comes to us because they were visited by CI. So it's too late to do this. But for cases that we have that are not yet criminal, and as far as I'm concerned, every case has the potential to be criminal, and we should treat them as such.
You can share your screen now.
Even if we know that, of course, all of the clients of Moore Tax Law Group are innocent, so there are no cases that should be criminal out of this firm.
My clients are not guilty; they're just misunderstood.
Right. So, in all seriousness, though, so can you see this PDF?
We can.
Okay, so this is what we send to our clients when someone becomes a client of the firm. They get an index card, and usually we give them 3 of these index cards. And the index card says, "I unequivocally invoke my right to have my attorney present during any questioning. I unequivocally invoke my right to remain silent. I do not agree to speak to you without my attorney present. My attorney can be reached at the information below. Contact her now. And these are little index cards that we have created. And we give these to people. Okay, I'm going to stop the screen share now. I don't know how to do that. Sorry. We give these to people at the beginning of a case. And oh, there we go. Stop share. Okay. And say, keep one at your office, keep one in your car, in your glove box, and keep one at your house near the front door. Because Eric, as you talked about, people will stand in their driveway as they're coming home, and then here comes the agent, and they'll stand in their driveway and talk for 2 hours without an attorney present.
Right.
Or someone will invite the agents in to sit and talk for 2 hours, or
And have coffee.
Yep. So first things first, which is to the extent that we can prevent that communication without an attorney present from happening, because it isn't that the clients are guilty or are going to say something, it's that they're going to be misunderstood, right? Or let's be honest, right? There are people who should never be talking on their own behalf under any circumstance. And we certainly don't want to compound a situation by making it worse and having someone who has said something untruthful to an agent in the course of that communication. So the more that we can try to head that off at the pass, the better. So I'll now answer the question that you actually asked me, which is what are the kinds of criminal tax cases that we see? So in general, there are all sorts of types of cases, but in general, typically we see them fall into two buckets. And one is evasion of assessment, right? So this is somebody who either doesn't report all of their income or over reports expenses or doesn't file tax returns at all. These are people who we're talking about evasion of tax being assessed in the first place. And then the other bucket is evasion of payment. Someone who either has self-reported tax that is due, right? Your tax return was filed and it showed that you owed $1.6 million. You didn't pay it. You go in and you get currently non-collectible status every year, but you're sitting on a mansion in Malibu. That's problematic. You don't tell the agent about the mansion in Malibu. That's problematic. So evasion of assessment is either the failure to file entirely when you know that you should file and you're not having taxes withheld, or filing a tax return that does not include all of the income that you received or constructively received, or over reports expenses. And then evasion of payment is either you've self-reported it and you said I owe this money, or you reported you were audited and the IRS assessed additional tax and you are doing things to avoid payment. And in any event, what the government will have to prove is an intentional violation of a known legal duty. And as AJ can attest, and I think all of us know, the government, when they decide to bring those cases, is incredibly successful in doing so.
For those cases that the IRS forwards for prosecution that actually go to trial, the government has never had less than a 90% conviction rate. And I think that's for a couple reasons. One, the normal life cycle, right? The CI has now spent thousands of, I don't want to call them man hours, professional hours, right? Men or women building, working this case, getting interviews with witnesses, getting documents, statements from people in their driveway, all of that. That then goes to the Department of Justice Tax Division, where some pretty bright trial lawyers are going to be going through that, poking and prodding and trying to see, is this a good case? Is it not? They can then send that, right, AJ, back to the field to keep being worked if they don't think there's enough, or they can forward it on. I forgot about Office of Chief Counsel has criminal counsel assisting the special agents as well. It'll then get to an assistant U.S. attorney like AJ, who would review it with the special agents, then present it to a grand jury. So by the time that case goes to trial, if you think about it, there are a lot of really sharp, bright people on the government side that have pulled that case apart and believe it's a good case. Now, it doesn't mean it's not 100%, but north of 90% year after year after year since, I want to say since 1916, is a pretty good track record. CIA celebrated its 100th birthday, I think 5 years ago. Never had less than 90% success rate. So I think that kind of stands for its own. So to get back to our sort of premise on the life cycle, so CI gets a lead. It can be from the civil folks, right? It could be audit or collection. Department of Labor, the state departments of revenue and or labor, whistleblowers. I just did a whistleblowing program with Mike Villa. We like whistleblower cases. I like when they pay. Ex-spouses, former employees tend to become whistleblowers. But in one way or another, that case finds its way to the IRS Criminal Investigation Division, who will then work this case. The case then will head to DOJ. AJ, were you ever at the Department of Justice in Washington, or were you always actually out in the United States Attorney's Office?
I was at the U.S. Attorney's Office, yes. Yeah, I would.
AJ, what would be so interesting, can you talk about the internal discussions about
Of course.
charges are approved?
Yeah, and I was going to say that, right? So amongst the other reasons you were pointing out, Eric, why the government has that high a conviction rate, and in some judicial districts, it's actually well north of 95%, is that the government almost never prosecutes innocent people. I mean, I say almost never because our clients, of course, are innocent, but almost never prosecutes innocent people. And you mentioned the people reviewing it and taking the case apart, and the agents coming to the to the AUSA and convincing her that the office should take on the case. But then the AUSA herself has a huge hurdle to cross. The AUSA then has to convince her supervisors that the office should indeed take on the case. And so, that begins with putting together a prosecution memo that lays out all the theories and then discusses all the evidence that is available, and then discusses any evidentiary issues that could prevent the government from introducing that evidence. So the AUSA's task at that stage is to convince her supervisors at a meeting, and usually the US attorney is present, the criminal chief for sure is present, and the chief of the economic crimes division is for sure present, to convince them why the office should take on that case. It's only after she has convinced those folks that the office then decides to take on the case. So the process internally is geared towards weeding out not just innocent people, but defendants against whom the government believes they might not be able to prevail, notwithstanding that the defendant in fact committed tax crimes. And I would also like to add one more thing. All the different crimes that Gwen mentioned. IRSCI often also does, in addition to the crimes listed in the tax code, which is codified in Title 26, IRSCI also investigates crimes that are in Title 18. So just because IRSCI is involved doesn't necessarily mean that there will be a tax prosecution at the end of it. There might be a money laundering prosecution.
Right.
There might be, a mail fraud prosecution.
Right. Well, nobody investigates financial crimes better than IRS special agents. But one of the things that's interesting, if you're listening to this, in all of this review, there is an opportunity for defense counsel to make sure that the government has thought about everything and seen everything. And for a while, we had actually a really good streak of getting cases killed by DOJ. In fact, for a little while, I was telling a friend of ours, when I know at the bar, I'm like, we got this killed, that's, and she was like, don't get cocky, but we probably had a string of 3 cases getting them killed. And so what happens, when I'm sure you do this, when
Can I ask you a quick question about that? Because I think this sheds a lot of light on the process as we're talking about the goal for this podcast. The cases that you got killed, did you get a declination letter, or it just went away?
So I'll tell you, I did not. I think in one we got an actual formal declination letter, and so if you're listening, what this is Department of Justice, the tax division, the criminal folks there have reviewed it and are declining to pursue the prosecution. In other words, they're not taking the case. Now, technically, the case goes back to the field where CI could keep working it and then resubmit. But in my cases, and I think CI knew they were bad cases, and they all came out of one office, by the way. They waited until a week before the statute ran before they sent it. And so what happens is, just, it's just part of our process. And I'm sure Gwen has the same thing. When we know we have a criminal case, I immediately send a letter to DOJ, to that division, Northern, Southern, Western. We represent this taxpayer. I understand they're under investigation. We would like to make sure we can have a conference with you before you make any decision on the disposition of the case, meaning we want to talk to you before you just rubber stamp this thing. And we had this where it was a week before. So Gwen, I literally get a call from an attorney at DOJ who I know, and said, Eric, I got the letter from you and Lisa. We're up against a deadline. I can give you a conference tomorrow, but it's by phone. This is before COVID. He said, you can't show up here. There's not enough time. And so I began explaining what had happened. And he and the other attorneys on the call said, whoa, stop. What is this? And when I explained, in that case, there's another defendant that's an active case. We're not representing them, so I don't want to get into the details. But what they were doing and why we thought that this was not their fault, CI had left that out of their write-up to DOJ. And so the DOJ lawyers were like, we don't know what you're talking about. So I walked them through it and I said, can I send you these documents? Because they were given to CI. They said, yes, we faxed it over. We don't hear anything. And now, fingers crossed, we're waiting. Lisa, by the way, on the last thing on the call, she said, look, attorney who she worked with at DOJ said, I have the highest degree of respect for CI. There's a reason this was missing, and there's a reason they waited till the 11th hour to give it to you. She said, and I don't say that lightly, but I think they were hoping you would just rubber stamp this. So we, fingers crossed, we wait a week, we wait another few days, and I email, say, hey, what's going on? I just got an email back saying DOJ is declined.
Wow.
I didn't get a formal letter. I only have that email, but for us, that was good enough. So, yeah. But the point is, from the defense side, there is an opportunity to, and this is why I think you always take the meeting, is one, you'll learn something, even though it's not really a reverse proffer from the government. It's not their job to tell you everything. They usually will, though, if you ask, but it's an opportunity to make sure they've heard everything. And by the way, that is unusual. I've never in any other case had special agents not share everything. I don't tend to have agents that go rogue. I would tell you in 22 years, 99.9 of them are upstanding people, and no one wants to prosecute an innocent person. But that is a big opportunity.
Yeah, and I think they share everything because they want us to be their partner in convincing the client to plead, right? They want to say, look, we've got this is not a good case for you to try. But I am curious, AJ, from your perspective, what is the reason behind, in some cases we do get a formal letter declining to bring charges, and in some cases we don't? I certainly have my theories, but I'm curious to hear from your.
Yeah, so I would say that the formal letter saying that they are declining to prosecute is the exception. And in the normal run of cases, the government just, if it has decided internally that it's going to decline, just doesn't communicate that outside. The reason I think is, as Eric mentioned, sometimes the agents would like to go back and rework the case, and it's not, the AUSA's job to tell the agents not to do it. Sometimes they might think that it might not apply in all tax cases, but sometimes they think maybe the state, the DA's office might be interested in bringing some financial crime charges, so they don't want to send a letter saying that they're formally declining it. But generally, I think they just believe that it's better for somebody who's living closer to the edge of the law to be fearful. And
Yeah,
they might be getting some deterrence out of it. So they don't want to broadcast that they're not going to bring charges.
well, and it is, it's interesting that you say that, because certainly for our clients who, by all indications, there's been a decision to decline to prosecute, but we have not received the letter. Those, and we internally say, okay, well, we think the statute is X, right? And you're never 100% sure, because for those of you who are listening to the podcast, the statute of limitations runs from the last affirmative act of evasion. And my assessment of what I think the government thinks the last affirmative act of evasion is might be different than internally what they're thinking. But usually you have some idea, plus or minus a year, right? And you can at least say, okay, 6 years from then is when the statute expires. That's a long time for someone to live with this cloud hanging over them. And it really is a cloud hanging over them. And people feel like they can't move on with their lives in many regards. And applying for a job, should you disclose this? Do you have to disclose this? There's nothing other than being under investigation. And that is emotionally difficult for people. But unfortunately, I think the answer is it's just too bad. You're not going to get a letter 99% of the time. You're not going to get it.
Mm-hmm.
Yeah, I think that letter is the exception. And I would like to maybe ask Eric what his experience has been, where he received the letter. I mean, what was it about that case that was?
I have no idea. I've only gotten a declination letter once. As I think about it, I don't know that I've ever gotten one in another case. Even CI, when they close the case and send it back to civil, there's a letter, that they can send saying, we're closing our file, returning it to the proper civil division. However, we can re-enter the case if new information comes, blah, blah,
right.
blah. I think I've only got one of those. In fact, when I give these webinars, I keep using the same letter from like 2014 or whatever. I think it's the only one I've ever got. They normally just, they'll tell you verbally, we're sending it back to civil. And then you never hear anything from them again. Which I have to tell you, there is a shock and awe factor for the taxpayer who is walking around worrying if they're still following him. I mean, I've gotten some weird text messages. Do you think they're watching me through my computer? Do you think, I'm like, no, I really don't think so.
Yeah, but that's what I said. They think they can get, deterrence at the margin out of this threat hanging over the taxpayer's head.
Yeah, and in fact, can and do, which is good, right? I think the one thing that defense lawyers and prosecutors can agree on is that we want to encourage voluntary compliance, and it is our job to help our clients comply, right? So to that end, I think it's a good thing. I just wish that they would let people move on with their lives. Just say we're
clients are innocent,
cute, but that doesn't mean anything.
right? And so, by the way, so the case goes to DOJ. DOJ says, no, we think it's a good case. Now it gets to AJ. And usually AJ, I don't want to speak for Gwen, but I can guarantee 99.9, she's going to want to come in and have a meeting with the assistant U.S. attorneys. We always do too. And so if you've never been in one of these meetings, in a way, it's too bad because normally you'd be part of the defense team, and that's a cool spot to be in. I never would bring the client with me.
Never.
Yeah, no. And
Never.
no, there's never a reason to bring the client almost anywhere, to be honest with you. Not to a civil audit, not to a collections case, not to an appeals hearing. Tax courts, you kind of have to have them there, but again, when they're pleading maybe, but other than that, you don't want them around. Because they have a tendency to say what they think they want the other people to hear. And it's just bad. So, but you meet with the assistant U.S. attorney, usually the special agents will be there. Sometimes if you're in a state with an income tax or whatever, where they're involved, we've had the state special agents also there. And usually, there's a proffer and there's a reverse proffer. AJ, can you explain sort of the difference between the two and when the government might be willing and why the government, Gwen already kind of alluded to this, why the government is willing to share information?
Yeah, sure. So sometimes the government is willing to hear from the defendant what the defendant can offer to the government, right? So that's the proffer. And the government is willing to listen to see if what the defendant is willing to share can help the government build its case maybe against other defendants. And so the government doesn't promise anything at that stage, but it's willing to listen to figure out what it is that the defendant might be able to provide and how that might help the government build its case against other defendants, maybe related to this defendant, maybe not related to this defendant. The government is mostly there to listen. So the agents are there, as you point out. The AUSA is there, but they don't do any of the talking. They are there to listen to what the defendant has to offer. So so now we're talking about the proffer. Unfortunately, for the proffer, the defendant has to be there. So initially, we started talking about the conference that the defense attorney sets up in order to dissuade the office from prosecuting.
Right.
At that one, yes, I totally agree. You don't want the defendant to be there. And you want to tell the government why they shouldn't prosecute this case. So you bring your theory of the defense, you bring all the evidentiary issues that you will be able to raise if that case were to go to trial. And again, the government just sits back and listens. And the AUSA welcomes such a meeting, because the AUSA still hasn't decided whether she is going to ask for that meeting, the all hands meeting that I referred to get the green light to prosecute. So the more she finds out about the potential problems with the case, the better it is for her. So that's a meeting that the government always welcomes, but the defense attorney has to be proactive to schedule that, to show up for that, and to put up the defense essentially. And that's where most of these cases are.
And
are
that's
one for the defense.
That's always, to me, there's a conundrum about, is there ever anything in those meetings that we want to hold back, right? Because on the one hand, the primary objective, by all accounts, the primary objective of these meetings is to convince the government not to indict, to convince the government to keep your client out of it. So you want to put every possible piece of effort you have into accomplishing that result. But at the same time, sometimes there are tidbits that you might want to keep so that you do have that element of surprise at trial, because in criminal cases, there is not formal discovery. And I'm curious to hear from both of you, how do you decide what you go in with and what you hold back?
Yes, I think it would have to be something really exceptional for the defense to hold back. Because think about it, if you are already planning for trial, right, you are already in some senses,
Yeah.
planning for the worst outcome. So
Yeah.
it has to be something, it has to be some trump card that you have that you're so sure about that you're going to hold in reserve. I can't really think of anything like that where you wouldn't want to bring it up. I mean, even if it's an evidentiary issue, right? It doesn't go to the merits of the case, but it's an evidentiary issue, and you're so sure you can keep a piece of evidence out. I would bring it up at that meeting. I would tell the AUSA, look, yeah, you think you might have him dead to rights, but guess what? You could never be able to get this in, and here's why you'll never be able to get it in.
Yeah.
And
Yeah.
so I would like to know what it is that you think. What is it, Eric, that you think you might want to hold back? Because I really can't think of anything.
Well, for what I tend to do, which tends to be straight up tax, what I find is it's not as much about, I can't think of anything that I would hold back. Because usually I'm trying to convince them to either kill the case, or if our client they did it, right? It's done. Usually I find I get the most bang for our buck attacking the loss number and beating up the loss and driving the loss down, because I happen to be, in the Second Circuit, where we lead the entire country in departures downward in sentencing. So for us, what I tell clients is, if we can convince them to drop it, great. If we know you're basically cooked, what we want to do is then spend our time beating up the number. And so what I tend to find is we do a lot more reverse proffers. Tell the government, we don't understand where you're coming up with your numbers. And then once we kind of lay that out, start beating that up, because I've never gotten to, actually once, I got the number to the point where I remember the special agents literally got up and like, we're out of here. And they walked out, which I've never seen before. It's like something out of a movie. They literally got up and walked out. But for the most part, what I'm playing at is the sentencing table, right? Can I get them from zone C to zone B? And zone B, now, if my client accepts, pleads, makes full restitution, stands up there mea culpa, and we have 17 witnesses of all the wonderful things he's done, in Connecticut, there's a decent shot he'll spend 3 months, probation. So I tend to spend more time battling on the numbers. So I can't think of a case where I've had an ace that we've held back.
But if you're beating up on the loss number, you've already indicated, right? Maybe formally indicated to the government that your client is going to plead, right?
Oh yeah, and sometimes we can even negotiate. Say, look, well, and this goes both ways. And again, Gwen, I'm sure you've heard this, and AJ, you've probably said this to people like me. Look, here's where we are. We've done X, Y, and Z. We've got a tax loss of 275. If your client's going to plead, we're done. If they're not, we're going to then look at all the bogus charitable deductions and the mortgage fraud and the this and the that. And now that 275 is going to go to 475, 575. They're going to start marching up. Now they're not going to get a 3-step drop for cooperating. And now you're looking at not 12 to 18 months, you're looking at 44 to 50 months, which is real time.
Yeah, and I also think it's important to think about straight up criminal tax evasion is not a forfeiture crime. but that's the exception and not the rule.
Yep.
So you never want to be in the zone where you're talking about, in addition to everything else, forfeiture.
Where the government gets to pull up with tow trucks and start taking your stuff.
Yeah.
Yep.
Right.
Yep.
That's why, the government throws in all those Title 18 counts in there too.
Yep. Oh yeah, no, it's if I would, and Gwen, I'd be well, actually both of you, now that you'd be AJ, you're on the defense side. I in my mind, it's always been sort of a 2-track. Can we show that the client didn't do it? No, we're moving to the next track, which is now I'm really gearing up for the sentencing because my client's going to plead. And so it's attacking the number. It's having them raise the money for the restitution. It's finding all 17 of these people they helped save from a burning building, whatever it is, all this stuff. And by the way, and just if you're listening and wondering, does the government, the judges read that? So they do. At least our judges do. They read those character letters. I had a client. It was the worst case I ever had, but he was a friend of mine. And I wouldn't have taken it had I really known. But it sounded like BS. We took the case, and as we dug into it more and more, it wasn't BS. It was, and he actually did a lot of work helping people who were down and out get back on their feet. So he had 17 character letters, and they showed up to give the day of sentencing for him. And we stood up, and the judge is just reaming him. And I remember thinking, she is going to hammer him. She is going to drop the hammer on him. And she goes through this whole thing and then said, and then went through all of the letters about he did this for this one, this for this one, this for this one. And ultimately, when they say, do you have anything to say? And you always tell the client, do you understand? Yes, Your Honor. Do you have anything to say? No, Your Honor. Right? Yes, Your Honor. Do you have anything to say? Your Honor, I do. And I'm like, no. And he said, you mentioned that you don't want to see me here again. You will never see me here again. And the judge actually smiled, and instead of 18 to 24, she gave him 6 months.
Wow.
But I remember she was going through the litany of everything against him, and I was like, oh, she's going to kill him. But the point is, I think that to my mind is, once you're right, DJ, once we've kind of decided the client's going to plead, I'm much more focused on narrowing down the number because I know what's coming, right? It's the restitution, it's the sentencing guideline, even though they're not bound to the sentencing guideline, that's where everything is going to start, right? The conversation is going to start. And doing all of that. Now, interesting. Have you guys found this? Or you're probably better than I am. I learned the hard way years ago. Don't forget about the state, because clients that get through, we get through the criminal, and they got probation, they got 6 months. I had one in a halfway house Monday through Friday. I mean, we've gotten some very interesting alternative sentencing. And then the state of Connecticut shows up, and they come right in behind with all that. And the client looked at us and said, can they do this? Well, yeah, you pled guilty to fraud. There's no statute of limitations on fraud. And so what I've learned now is we can actually get a voluntary disclosure done with Connecticut, but I don't want to do it till we're ready to plead because of the fact that I don't want feds to pick up on the fact that we did a disclosure with Connecticut as kind of, hey, your client just said in their disclosure they did this.
Yeah, and states have laws that require taxpayers to affirmatively inform them about changes to the federal tax determination within a certain amount of time. At one point during the heyday of offshore voluntary disclosure, when we had clients from all over the country who were voluntarily amending pursuant to the OVDP, I had a chart that had every single state and what the rate was and how many days you had to amend in that state under the statute, and whether they had a voluntary disclosure program or not, because there was so much. So yeah, I learned that the long and arduous way during OVDP, that's for sure. It's interesting. I feel like the hardest thing for me is if you have a case where, for example, that deals with structuring and evasion, and you know your client's going to go down on the structuring, but you think you've got really good defenses on the evasion. The government's not going for it. But the structuring is going to come in no matter what, those to me are the harder ones, not as straightforward of like, okay, we're going to plead, let's focus on sentencing.
What bothers me, if I have one real axe to grind about this, and AJ, I'd love your take on this. It's the acceptance of responsibility when some of it is bullshit, and it's bullshit, but the client has to stand there and accept responsibility, because if they equivocate in any way, the government's going to be on their feet.
Yeah, not a valid plea.
Yeah, and so again, if you're listening, what I'm talking about is your client's going to plead. They can get I mentioned that depending which bracket you're in, a 2 or 3 step drop on the sentencing guidelines for acceptance of responsibility. But that acceptance has to be across the board. You don't get to pick and choose. I accept responsibility on the structuring. The evasion is bullshit. That you can't do. And that's like when my client said, do you understand? Yes, Your Honor. Do you have anything to say? And he said, yes, Your Honor. I was like, oh, no. Because sometimes clients want the judge to understand they didn't really do this, right? That they're not really a bad guy. And the moment the government hears that, justifiably in some cases, they're going to be saying that there's no acceptance of responsibility. What we're hearing here are excuses. And so AJ, first of all, did you ever have someone do that in a case that you were prosecuting? Did you ever have a defendant stand up and effectively not accept?
Yeah, and sometimes when even after signaling that they're going to plead, they try to play hard and really hard with some of the other facts. In fact, I remember going back to one of my supervisors and saying, not only should we ask to take back the acceptance, we should hit him for obstruction, because we get a 2-point bump up for obstruction.
Oh, you're so tough, AJ.
Right. So, if he's going to plead, he has to plead, and then he has to cooperate to get the right tax loss number. He cannot be, playing fast and loose with the tax loss number at the same time.
There's a time and a place. I mean, and Gwen, I was going to say, I agree with AJ. It's not like you're at the negotiating table and you get to get up and walk out and pretend you're going to walk away from the deal. That's not what we're doing here. I think the time for that shit is when you were fighting over the numbers. Now that you have the numbers and there's going to be a plea deal, it's over.
Right. But that's why I say nobody should ever straight up plead. You should always plead pursuant to an agreement, and that's where the defense attorney has to come in and make sure that what he's pleading to is what he'll be comfortable accepting responsibility for, and what he will cooperate in terms of establishing the loss, and so that the guidelines can be relatively easily agreed to by both sides. He can't, after pleading, he can't then not cooperate with the probation office to get a good PSI and not provide the details that are needed to establish the tax loss. So I think the negotiation should take place pre-plea, where you decide what he'll actually plead to.
Of course.
Yeah, for sure.
Yeah.
And what the recommendation is going to be by both sides.
Right. I mean, ideally,
that should never be a surprise.
No.
Yeah.
No.
I mean, you ideally you want to recommend, both sides should agree on a recommended sentencing range.
And by the way, understand, for those folks who do civil work, there will virtually in every case although I've seen rare that they don't, but in virtually every case, there'll be a request for an order of restitution from the government. That restitution order, the IRS can then take and turn into a civil assessment that they will pursue. They'll add 75% civil fraud and interest to it. That restitution amount cannot be compromised. All right, it's not subject to, the IRS has no authority to compromise what is effectively a court-ordered restitution. So I've had clients say, I'll plead that whatever the number is, doesn't matter, I'm not going to pay it, we'll just compromise it. Well, no, you're not going to just compromise it. Which by the way, is why if they can make restitution, yes, the IRS will come in with the penalties and the interest. That can be compromised later. But also it looks good to the judge when you say, I'm accepting responsibility, full pay the restitution to the government, and I'm sorry, and basically you throw yourself on the mercy of the court. That I mean, obviously it depends on the judge, but that I think goes a long way in lightening the ultimate sentence.
Yeah, that's for sure. And I think it's also important to point out, even if both parties agree on what the recommendation for sentencing will be, the judge is not bound by that agreement. The judge is going to make his or her own determination about what sentencing should be. And, we advise our clients about ways that we think that they should behave and comport themselves and conduct their financial affairs. And unfortunately, not everyone does what I say whenever I say to do it. And, we've had clients who, when they come in, your PSR, the pre-sentencing report, is a pretty deep dive into all of your financial affairs. And if the judge sees things that you have bought and acquired leading up to sentencing, be ready to defend that and talk about that, because someone who's coming before the judge for any sort of financial crime and you're buying a luxury car, the judge is not happy to see that.
No, it's clients that basically stole money to keep their business afloat, to barely scrape by, I think look better than high-flying lifestyle people who were just cheating and got caught. If we talk about, accepting responsibility and all that, I have a friend of mine who's an estate planner. When he first started, I'll just tell you this because it's a very funny story. When he first started out at a small firm, they said, look, we have this big client. The son got arrested for whatever. It's a state case. We've already worked out a deal. He's getting probation. You just have to go with him to the hearing. Two things. He'll stand up. Do you understand the charges? Yes, Your Honor. Do you have anything to say? No, Your Honor. Sit down. He's been briefed. Just go cover this. So they go to he goes there, beats the client. They go in again, stand up. They read the charges. And you're pleading guilty. You understand this? Yes, Your Honor. Do you have anything to say? As a matter of fact, I do, Your Honor. And he went on a 3-minute tirade, including 4-letter words thrown at the judge that you do not call a woman. And when he finishes, my friend tells me there's ringing silence in this courtroom. Like the peanut gallery, in the state courts, it's dead silent. And now no one is saying anything. And he's looking around. He finally said, he's a first-year associate. Your Honor, I'm sorry. And she looked at him and said, call him Smith, Mr. Smith, you don't have to be sorry. You're going home tonight. And she gave him 3 years. And in state court, you don't get to go home and turn yourself in with your toothbrush. Marshals came in, took him in handcuffs, dragged him out of the courtroom. 3 years. So he had to go back to his office and tell the senior partner what happened. And the big client's son just got 3 years in state prison. Is on his way there now. Don't do that.
Don't do that. Yeah, don't do that. That's for sure.
Yes, I would say two things about the civil implications of a criminal plea. First of all, the AUSA really doesn't care about the civil implications. What they want to see is, can they get a custodial sentence? If they're not going to get a custodial sentence, a large enough tax loss number for the mandatory restitution order and probation, they don't care what the civil folks will do. So that sometimes, often I would say, gives enough room for defense counsel to negotiate a good plea where they can minimize the civil fallout of it. The other thing I'll say, you're exactly right, Eric, that there is a mandatory restitution that will accompany a conviction. That is collected by the flu unit of the local U.S. Attorney's Office. But now we have a provision in the code that allows the service to make an assessment, right? So they can assess such amount as if such amount were tax. And for the first few years after that was added, the service was taking the position that not only will they assess the amount of the restitution, which often has already been collected, but then they'll go back and add underpayment interest to it, and they'll add penalties to it. But the tax court decided, in a really well-written opinion, that even though it said as if such amount were such tax, that did not make it tax, and the service cannot add interest and penalties to the restitution that has already been collected. And even though a defendant has agreed to a tax loss number, for civil purposes, he is completely free to argue for a lower amount of the deficiency for that relevant year.
Really?
Yeah. Defendants agree to tax loss numbers for a host of different reasons, and they might not claim all the deductions that they're entitled to.
Oh, I got to pull that case.
Yeah.
Yeah, so the case is Klein v. Commissioner, and it's really well written, and it explains why the service cannot add underpayment interest and penalties.
What was the name of the case?
It's Klein v. Commissioner.
Oh,
Just like Klein conspiracy, Klein v. Commissioner. Yeah.
But a different Klein.
yep,
It's a different Klein. Yeah,
Yeah, the Klein conspiracy's been around a long time.
right. But it's a different Klein. This is a 2017 case, and I don't know whether there's been a formal acquiescence in that, but I know that the service has since dropped that practice. They no longer go back and add underpayment interest and penalties.
What? I got to think about that. When's the last time I had a case where we had the civil fallout? Was it before 17? I don't think so. But I got to look at that. That's interesting. I just learned something.
Yeah, I mean, that was especially egregious, I thought, because in that case, the service already had the restitution. And if you go back and look at the legislative history of that provision, all that provision, I think, sought to do was allow the service to make the assessment. Right? It was a bookkeeping entry. We already have the money, but we can't call it tax revenue until we have a corresponding assessment. So that Congress said, okay, you can make the assessment. But you give the commissioner an inch and he'll take a mile. They said, oh, not only will we assess it, but now we'll go back to the year for which the restitution was made, and add underpayment interest for that, and we'll add failure to pay penalties for that. And the tax court said, no, you can't do that.
Things like when you give the commissioner an inch.
Yeah, I thought that was extremely egregious, because oftentimes what happens is the district court will add, right? There's mandatory interest that runs on the restitution order. Yeah. The Title 18 interest.
Well, and the complicated part about it is, of course, that in general, the commissioner is prohibited from making an assessment for any liability in dispute absent issuance of a notice of deficiency, and then either the taxpayer doesn't file in tax court or files in tax court and loses. So this idea that there needed to be a mechanism to make an assessment is not without merit. That's for sure. There is a need for a mechanism to make an assessment in a criminal case. But certainly the idea that the commissioner gets to double dip is not only wrong, but I think does not encourage voluntary compliance, right? Anytime you have the government doing something that on its face is inherently unfair and making someone pay twice, I think instead of having the impact of encouraging voluntary compliance, people think this is crazy. Why would I want to do that?
Yeah, oftentimes it's just the civil agent being lazy, because they don't want to do the civil, they don't want to complete the civil exam. And so they're just going to say, okay, well, he agreed to a tax loss number. He has paid the amount. We'll just make the assessment. All right, now we have the assessment. Now let's go back to the year to which the restitution related, which could be like 10 years, 15 years back. And now we'll add the interest going back. But what they should do really is complete the exam, allow the taxpayer to show up for the exam and find out what the civil deficiency number is, and then proceed based on that. But you're right. I mean, many things will be res judicata, right? I mean, if there's fraud, there's fraud. You can't argue that the civil fraud penalty doesn't apply because he's been convicted of fraud. But the tax loss number itself doesn't definitively determine the deficiency number for civil purposes.
It will
And
be
that's
true.
why it's so important to be careful when you're talking about what are you pleading to, right? Because if you want to leave the door open to disputing the civil fraud penalty, then there are certain things you just can't plead to.
Right. And that's where I think a defense attorney should take advantage of the fact that the AUSA really doesn't care about the civil fallout. The AUSA wants, if possible, a custodial sentence or a high tax loss number.
Right. So has anyone considered, in light of the Klein versus Commissioner, the new case, to go back now and challenge penalties and interest that were applied to people that pled beforehand?
Yeah. I mean, I don't know that, it would have to be sort of a strange fact pattern, right? It would have to be a fact pattern where the civil exam began, the civil exam was cut short, there was a prosecution,
Yeah.
then there was a mandatory restitution order, and all of the amount was paid, and then the civil examiner agent never in fact completed the exam, but just tried to piggyback on the restitution order to add interest,
Right.
and penalties. Yeah, I don't know. I mean, I
Well,
don't know if anybody on the defense side has done that.
Yeah, I mean, well, that usually happens. So they plead, right? And inevitably a civil auditor, the cooperating agent, shows up and they give you this, this report, basically taking the restitution amounts, the tax loss numbers by year, and adding on the fraud penalty and the interest, and they want your client to sign. We usually refuse.
Right.
And, and then we end up getting, they're usually in prison by the time the bills start showing up. I'm just curious if anyone has gone back and filed a refund claim if they did pay it, or if they didn't pay it, file to have the assessment, challenge the assessment.
Yeah, that's a good question. So Klein versus Commissioner, the site is 149 TC number 15.
Yep.
And there's
it's 149 TC 341, I think, right?
Yeah,
The
sorry, I'm
page
looking at
number,
the
right.
TC number, which is always so confusing that they have those two different ways of citing it. And then there's a chief counsel memo.
There is an acquiescence on it?
Yeah, it's CC 2019-004. and it's written by Kathy Zuba, talking about, as you said, that the service did not appeal that case, and setting forth the internal procedures for how they're going to be viewing these going forward, and agreeing that the failure to pay penalty does not apply to an amount of restitution assessed under 6201.
Right. So there used to be a parallel provision for child support, right? Child support is also assessed by the service as if such amount were such tax, but there Congress had specifically said you cannot tack on penalties to that. And here, the provision doesn't say that. All it says is, the service can assess the amount of the restitution as if such amount were such tax. And the service said, aha, they didn't explicitly carve out penalties, meaning we'll tack them on. But I think they were just being a little too greedy.
Listen.
Yeah.
All right. Well, any other thoughts? Is there anything we haven't covered? Oh, there's a lot we haven't covered, but in terms of lifestyle, one thing I do want to just say for those people listening, as AJ pointed out, there will be a one of the, at least here in Connecticut, it's one assistant U.S. attorney who is assigned to collection. So they will be trying to collect for the government for as far as the restitution DOJ. The IRS will also have revenue officers attempting to collect from their side. Usually what we do is we will try to work out an arrangement with DOJ, which will make the client uncollectible for IRS. So we set up I try to set up the DOJ because normally I just want to get the restitution paid, knowing again, whatever else the government had prior decline would be, could be compromised. So I would try to set up the client in a payment plan. So when IRS did come knocking, we could submit a financial, effectively make them uncollectible for the IRS. Which doesn't always work, but usually that's what I try to do.
Yeah, it's interesting because, Eric, as you point out, some things can't be compromised. And in any offer and compromise situation, there's a final, after you have the review of like, what's your equity, what's your disposable income, what's the number, then you've got the, does acceptance of this offer and compromise further, or does it dissuade voluntary tax compliance? And if you have somebody who's got a conviction, even if all the numbers work, it's not going to get accepted.
Yeah, what I have found is if the client's made restitution, they will go through. I've had people who try to bring me in later where they filed an offer saying that they would only compromise the rest, not the restitution. The IRS, they don't do that.
No.
Those always get shot down. The one that I did where it was a combination, she had pled guilty, did jail time. She owed about $203,000, somewhere around there, of restitution, but $475,000 for some other income tax and the other stuff. I was working with a accounting firm out of Kansas City on this. And what I said is, look, you do the offer analysis, it's $70,000. Submit that. It was a collection due process hearing. Submit that. And the offer is, look, the RCP is $70,000. However, IRS, we know you can't compromise the restitution. That has to be full paid. She can borrow from family. She's offering $205,000 or whatever it was. So the CPA firm called me and said, they got a call from the settlement officer who said, I understand what you're trying to do. I think we can do this, but no one here knows. We've never seen it before. So we sent it to Washington. They accepted the offer for $205,000. I think that you think, well, they pled guilty and the IRS wouldn't take the offer. I think that the feeling that I've gotten is if they can turn around and say, we got the full restitution, we didn't compromise on the theft loss, they didn't benefit from this, I think they'll take it. That's been my experience so far. But you just know that you can't compromise restitution. And I get calls from attorneys all the time like, well, can't you do a comp? No, it's court-ordered restitution. Well, she's broke. How do we get this fixed? Call the AUSAs. You have to convince them the number is wrong, why the number is wrong, and then convince them to go back to the judge to explain why it's wrong and get it amended. And they're like, yeah, that's not going to happen. I'm like, no, it's not going to happen.
Right.
But-
So the restitution cannot be compromised with the service as part of a CDP hearing, but restitution is part of the criminal sentence, right? So you can file a motion to amend the sentence under 2255. I mean, chances are, the judge will not be too favorably disposed to, but if facts have significantly changed, right, you can make an argument. So the vehicle for attacking the restitution is to have the sentence amended, not to ask the service to compromise the amount.
Correct. And so the issue, at least here, the sense I've had was I'd have to explain to the judge why the number was wrong. And
Right.
by the time you get to that point, that is an uphill battle.
Yes.
I suppose maybe in dire circumstances, maybe it would have to be beyond hardship kind of thing. Maybe one of our judges would consider, but I've never tried it. So for the record, I've never tried it. I don't know that I would feel comfortable going and trying to sell that to a judge, that the number's right, there's nothing wrong with the number, but the person's just broke and can't pay it. Listen, you can be uncollectible, right? I've had folks that are effectively, they're done. They're disabled, they were elderly, whatever. And DOJ the AUSA can deem them uncollectible and just revisit them every year or two or whatever.
Right. So it's not like this person is without a remedy. They're just also, somewhat to what we're saying, you're not going to get a declination letter, and this is going to be hanging in your head. If you have the restitution order, then no one is going to say you don't owe that money. You just are not going to be forced to go into absolute destitution to pay it.
Right.
But if the service is trying to use that assessment, right, to collect something. So if they're trying to use their ability to assess the amount of the restitution, then that is open to a CDP challenge. You see what I'm saying? Right.
Yeah.
I mean, so the client case itself, it was a CDP case.
Yeah. Oh, listen, as far as collection, uncollectible is available. Installment agreements are available. The one thing that is not available is compromise or discharge in bankruptcy. Yeah. Those are the two things that are just off of the four collection alternatives, if you will. I'm not including full pay. Full pay is always available, but if you can. But of the other four, two of them are off the table. You can still be deemed uncollectible. They can't collect what they can't collect. And you can always get into a payment plan based on ability to pay, but you're just not going to be able to compromise it or discharge it.
Yeah. And you know what, Eric, thank you for saying that, because oftentimes it's our jobs to be brutally honest with our clients, right? And full pay is an option, and often it's the best option. And if you have a client who has the capacity to full pay, you need to be having that conversation with them.
Well, if for especially the restitution, we have clients, if you can beg, don't steal, but beg, borrow, and get it from somewhere.
Beg, borrow, and look under couch cushions.
Yes, it goes way better for you at sentencing. You get out from under this. Those are the people that get to just move on with their life and go about their, get themselves straightened out and go on. But I've had people call me. One was, she was convicted of embezzling from a bank. It's like 8 or 9 million. She's broke, and so the lawyer's fighting with me. You got to compromise. I can't compromise it. And, you know, she kind of assumed when she pled that she was never going to pay it anyway. She would just compromise it later. And oops. No, much better off having those upfront conversations so that there's no fight or basically, you know, this, you know, why didn't you tell me, you know, later. And in fact, along those lines, it's one of the reasons why if we don't get a reverse proffer, well, if the numbers aren't making sense, we really want a reverse proffer. It's mostly to understand that. And usually, you know, I'll tell you this, AJ and Gwen, funny stories. When usually I come back, I walk the client through it, and they'll say, yeah, that's probably right, or it matches what our forensic people are telling us. But I had a case where it was a preparer, and what the preparer is doing, AJ, you come in to get your return done. She says, does your return, you're getting $1,000 back. Sign this 8888, which is a form that splits the refund. You get $750. I'm going to take $250 for my fee. AJ, you take your return, off you go. As you're not even in your car, I go back into your return and I start magically creating expenses. So now you're getting a $4,000 refund. You're still just going to get your $750. I'm taking the $3,250. And so I sit down, the AUSAs walk us through this with the special agent. I go back, explain this to my client. My client literally says to me, that is a lie. That didn't happen. I didn't do that. Okay. I called this special agent, said, look, I don't have all these banking records, and I know the CI agent very well. I said, Bob, you can trace this. He said, Eric, I can trace from the return that went in right into her personal bank account. And we have copies of these returns that she gave to her clients because we went and interviewed 50 of them. I tell the client that. Nope, they're lying. Didn't happen. I'm telling you it didn't happen. So I emailed Bob and I said, Bob, can we get together and can you show me this? My client's denying it, which I've never had. My client is outright flat. I mean, especially something like this, which is on paper, right? I mean, there's a paper trail. Flat out denies it. The AUSA called me up and I didn't know her well. And she starts yelling at me on the phone. This is a waste of time. I can indict her right now. Blah, 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 blah. And I said, hold your horses. Let's call her Mary for the moment. Mary, hold your horses. I said, think about it from my perspective. My client's denying it. Now, I'm going to off the record tell you, I've never in 20 years had Bob, the special agent, ever outright lied to me. I am pretty sure that when I look at that paperwork, it's going to show exactly what Bob says it shows. But think about it from my perspective. In 4 years now, she's out of prison. A lawyer calls me and says, why did you have her plead? Well, you know, this, that. Did you see that? No. Well, why did you have her plead? What do you want me to say? Mary told me so. And she said, okay, fair enough. So we had to meet in her office, but I met with them again and we went through 30 returns and they said, look, we have 100 more. Do you want to keep going? Nope, we're good. And I basically emailed her, said, and I just detailed some of them. Here's the deposit on this date, this amount, blah, blah, blah. But they wouldn't give me copies. But I have that. And I said, you need to plead. They have you. And if you don't, here they're going to move into the phony charitable deductions. And it's only getting worse. The funny part is I'm now giving a talk with Mary, the AUSA, a month later. And I said, Mary, so we meet up beforehand. I'm like, Mary, I'm sorry. Gwen, I don't know if you've ever been to Quinnipiac, which was the first.
Oh, yeah. It's
Well,
great.
we're in the jury.
Conference there.
Yeah, we're in the jury room that they have, which where all the speakers hang out. And I said, Mary, I'm sorry, my client won't return my call. She said, oh, Eric, I'm sorry, you got fired. There's a new lawyer that called about her, and he now wants to start all over again. And I'm like, oh, okay, well, I guess I got fired. So anyway, yeah, she pled guilty. I saw it when it hit the headlines.
I'm surprised the AUSA did a reverse proffer at that stage, though. I would never have done a reverse proffer.
Well, you know what? It was I think when they told me what happened and where they got the loss, the reason I think they did it, AJ, is when I called the client, and again, if the client had said, okay, what do I do? All right, so we're not fighting what happened. Now it's just about the number. When my client says, and I told them, my client's denying this. And so when she got pissed because I think she thinks, now this is a waste of time. But I think when I said, look, I believe you, can you just show this? Because at least that way I can tell my client, I've seen it. And here are the dates and the amounts. I think that's why they did it, in the hopes that I could then, convince my client, plead. It's in your best interest. It's in the government's best interest, plead. But I find at least most of the AUSAs will, in my experience, will do the reverse proffer. Mostly, I think, to convince me to convince my client. This is what we have, Eric. This is why. This is where we're coming up with our number. And it's almost always, this is where we are. I had one in the Eastern District, same thing, in New York, where they walked me through it and they said, look, we actually come up with higher numbers, but these are the numbers your client handed over their records. So we're just going to take their records. All right. However, if your client's not going to plead, don't forget about the unreported income over here and this and that, whatever. I think that they usually will do it in an attempt to get us to, we'll plead.
Yeah, but usually they would require some sort of firm indication that he's almost ready to plead.
Oh yeah. No. I mean, at that point, we come in and say, look, can you explain where you're cutting your numbers from? I think, there's usually the conversation of for me to keep my client there, what are we looking at? Because the client usually, Gwen, does your client say, what am I looking at for time? How much?
Yeah.
The plea.
First question.
Oh, yeah. Yeah.
And I think that's where, you should double check with the client. We always assume, right? He's willing to pay a lot more in order not to be in custody. But you'd be surprised. A lot of people are willing to spend 6 months in custody if you can get the tax loss number down.
Well, that, or what I find fascinating is the folks that say, I'll do the jail time and just get this over with.
Yeah.
And that way it's behind me. I'm like, well, yeah, but remember, we have to pay and whatever. And they're like, wait a minute, I have to pay? Yeah, the jail time is the punishment, but you still owe the money.
Right.
They seem to, for some reason, they think if I just do the jail time, I don't have to pay the money back.
Yeah, it's not mutually exclusive. Exactly.
Yeah, no. Oh, and by the way, if we can get you house arrest, you're going to be paying for your monitoring, right? And they don't like that either. I actually had one once tell me, said, I'd rather spend the time in jail then. Okay. Whatever. But all right, listen, guys, thank you for doing this. I hope people listening to this have learned a little bit something about the criminal tax process. Any final thoughts?
This has been a lot of fun. Thank you so much for having us, and hope to see you in person for the New England Tax Rep Conference later this year.
Well, hopefully I'll see you in person in May.
Yes, hopefully see you in person in May, or in DC for the FBA in March, maybe. We'll see.
Right.
Right.
All
Good
right.
luck. Good luck defending the wrongfully accused.
Yes.
Thank you, AJ. Thanks for doing this, guys. And, and everyone listening, thanks for listening in. And we'll see you next week on the Tax Rep Podcast.